Welcome, and thank you for joining us for the next installment of our webinar series. I am Amy Dickerson, and with me today are my partners Jennifer Smith, Jackie Wernz, and Nicki Bazer. Today we will be providing a year-end update on some recent hot topics in education, including the latest on the proposed Title IX regulations, what to expect under the administration of Governor-Elect Pritzker when it comes to our education administration and that agenda, as well as the latest on the issue of permitting school staff to be armed in schools. For those of you who are not familiar with Franczek, we are a law firm of approximately 40 attorneys who focus on labor and employment, education, and immigration law. Before we get started, there are just a few housekeeping items to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Everyone logged into today's program will receive an email that includes a link to the recording of the webinar as well as the presentation. Now let's get started, and I will turn it over to Jackie to walk us through a brief overview of the latest on the proposed Title IX regulations.
Thank you, Amy. This is Jackie Wernz, and as Amy mentioned, I'm going to jump right in and talk about the proposed regulations regarding Title IX of the Education Amendments of 1972. So by way of refresher, Title IX is the federal law that prohibits any recipient of federal financial assistance from discriminating against students, employees, applicants, or other persons on the basis of sex in its education programs and activities. And Title IX has long been interpreted both by courts and the U.S. Department of Education's Office for Civil Rights, which we often refer to as OCR, as requiring a school to respond promptly, impartially, and adequately to complaints of sexual harassment, including sexual assaults and other types of sexual violence in schools. In late August 2018, the Department of Education leaked a draft of proposed Title IX rules that would drastically alter the rights and responsibilities under Title IX in schools. The DOE informally published those proposed rules on November 16th, and the proposed rules were published in the Federal Register on November 29th, 2018. Amy Dickerson and I outlined many of the proposed changes in a previous Franczek webinar on October 23rd, 2018. That webinar was focused on the proposed rules, but there really weren't a lot of substantive changes between the proposed rules and the rules that were eventually published for comment. So we have provided a link to the webinar recording here, and you can also find it on our website. We do encourage you to go back and listen to that short presentation for many of the details of this sweeping change to the law. But since the comment period is now open for the proposed regulations, we wanted to hit some of the highlights today during our wrap-up year-end webinar. Okay, so some of the key changes. The first one here is that the proposed regulations do include a narrower definition of sexual harassment. So right now, sexual harassment is sort of informally defined by OCR as being conduct that is severe or pervasive enough to create a hostile environment within the school environment. The proposed regulation would define sexual harassment as conduct that is severe and pervasive and objectively offensive enough to effectively deny a person equal access to a school's program or activity. And this is a pretty minor linguistic change, but it could be a pretty significant change as far as what complaints or what types of conduct schools will need to respond to using their Title IX procedures. So it may be that, for instance, right now, one instance of sexual harassment, if it's severe enough, can trigger your responsibilities to respond under Title IX. But under this new definition, if it goes into effect, it may be that one instance of misconduct, even if it's pretty severe, might not meet the definition. And if the definition isn't met, then the school wouldn't have the responsibility under Title IX to respond.
Now, just to
interrupt there a little bit. So before there's too much shock. I mean, when I heard you say that, it's like, okay, so a severe instance of, so let's say a student is raped in your school, but it just once. So what I heard you say is perhaps that would not qualify as sexual harassment. Schools could obviously still address that because they have conduct policies and whatnot, but you're saying it's possible that would not trigger Title IX responsibility. That is shocking to me.
Right. I mean, I think that rape is probably going to be one of those circumstances that I would assume even under this definition, maybe OCR would say, well, the effects of the rape are pervasive and persistent even though the rape might have only happened one time. So I think this is one of the reasons that there's some uncertainty as to what this definition really is going to mean. Because I do think that you could interpret that circumstance as falling under even this new definition. What I think that the DOE was trying to pull back on are maybe circumstances where like a student is saying something to another student or a teacher is saying something to another student, one or two offhand comments that, under the current interpretation, if it was severe enough and if the student felt, if it was reasonably severe enough for the student who was the recipient of those comments, it would fall under this definition of under the old definition of sexual harassment. And that's where I think the DOE is trying to pull back a little and say, you know what, we're not going to require you to spend time and resources and money using these extensive Title IX procedures to address a few offhand comments. But I would be shocked if OCR didn't continue to find responsibility to respond to like rape or sexual violence, even if it's just one instance.
And Jackie, when we get the final rules, if that definition is still there, both the explanations of the rules as well as potential follow-up implementing guidance from the DOE is where we might look to see how OCR will actually be interpreting that definition.
That's right. Yes, we'll sort of have to wait and see what how it's going to play out in case to case on a case to case basis.
And this, among the other areas that you're taking us through that are in the proposed regulations, are areas where if there are concerns that school districts have regarding that definition, they can submit a comment to express that concern.
That's right, and they have a number of options for expressing concerns with these types of things. So you can submit a comment directly, and we'll include some information on that a few slides from now. You also can reach out to one of us if you want to share your thoughts, and we're happy to try to find a home of an organization or somewhere where a comment would be submitted where they could take that into account. And then you also can reach out to your various organizations that represent professional organizations to provide your comments as well. One thing I did want to point out about this narrower definition of sexual harassment that is interesting is that we do have other civil rights laws that are in effect, obviously, in schools that OCR enforces other than Title IX. So like, for instance, racial harassment. And it's the case right now that if, one use of one racial slur, if it's severe enough, can be sufficient to trigger responsibilities under other civil rights laws. And so we may find ourselves in a situation where you're now dealing with having to handle one stray comment differently depending on which civil rights law or which civil right is implicated. And we've been trying to push clients toward having one streamlined process for all of their grievance procedures, and now we're kind of moving to a place where we may have to consider having different procedures depending on the type of civil right that's at issue, which there's a lot of head shaking going on in this room right now because we know that that's going to be complicated for you. It's going to be complicated for all of us to have to wade through. Okay, so the second point here is what deals with what type of knowledge is going to trigger your responsibilities to respond under Title IX. And under the current regulatory scheme, schools have to investigate and respond to sexual misconduct about which they know or should have known. So this really means that if almost any school employee knows about sexual misconduct at school, the school is deemed to have enough knowledge that their Title IX investigative process is triggered. The proposed regulations would require schools to respond only to complaints of sexual misconduct of which they have actual knowledge. And that term would mean knowledge by a school's Title IX coordinator, knowledge by an official with authority to institute corrective measures, whatever that may mean, and in the case of a K-12 school, also a classroom teacher. So if the only person who knows about the sexual misconduct is someone other than those people, or noticeably, even if it's one of those people, but that person is actually the alleged perpetrator of the misconduct, the school is not going to be deemed to have sufficient knowledge to trigger its Title IX response. This is interesting, particularly in the K-12 context where the teacher is identified as someone who has sufficient knowledge or has sufficient responsibility to confer knowledge on the school. The reason being the close relationship between the teacher and the student, and the apparent authority, the in loco parentis authority and responsibility of the teacher. But, I really think that you could apply that same reasoning to a number of different types of employees within a K-12 environment. And so we're really going to be in a place of confusion as far as who is going to fall under this definition in K-12. And we'll have to kind of wait and see, again, how OCR interprets any final rule that might be issued. Another big change with respect to the school's response is that the school would have to, is with respect to the school's response. So that's the third bullet point here. And what this deals with is that how the school is going to be held responsible for, did it respond adequately enough? Right now, you have to respond reasonably to a Title IX complaint. Under the new rules, if they were to go into effect, a school would have to be deliberately indifferent. That's a much higher standard. And so this is good news for schools. I mean, the reality is that this means that OCR, if these rules go into effect, they're going to be scrutinizing your process much less than they are right now. Really, you get the feeling from these regulations that if you put your procedures in effect that are required by the regulations and you follow them, that OCR is not going to find a problem with your approach. But one area that is a little confusing, again, for K-12 schools is that there's this safe harbor that's put into effect for colleges and universities that essentially says schools are only required to respond to formal complaints, which is a complaint signed by either the Title IX coordinator or the alleged victim of the conduct. And if a student chooses not to pursue a formal complaint and a college or university provides certain supportive measures to the student, they're off the hook. They aren't going to be found to have violated Title IX. That safe harbor does not exist for K-12 schools. And so what we know is that there's going to be some circumstances where K-12 schools are going to be required to initiate a formal complaint even if a student doesn't want to. All schools are required to initiate a formal complaint if they learn about multiple instances of misconduct by the same perpetrator under these proposed rules. But for K-12 schools, there may be other circumstances that are undefined where they also would have to start a formal complaint even if a student didn't want to. And where we see this coming into play right now in schools is where there's a potential greater impact on the whole school community than just the impact on the individual student. So we'll have to see how that plays out. But again, an area of confusion, an area to think about, how might this impact you, and do we want to submit a comment to let DOE know about these concerns? All right, the final prong here is that there's going to be some new due process protections under this proposed rule if it goes into effect. So things like colleges and universities are required to offer a live hearing. K-12 schools can, they don't have to. Higher education entities are going to have to provide for cross-examination. That's not going to be something, again, required in the K-12 context because you don't have to offer a live hearing. But if you do, cross-examination would be required in that circumstance. Again, though, the general takeaway here from these is that there's a lot more due process built into these procedures, and there's going to have to be some pretty major changes to your policies and procedures if these laws go into effect. One last thing we did want to point out is that the proposed regulations do include some analysis of what the potential costs would be. We're really not going to get into the details of all of that at this point, but did want to point out one interesting thing. They basically laid out how much they think it's going to cost for schools to review and revise their policies and procedures, to provide training, and then to post required information about Title IX if these laws go into effect. With respect to training, we just thought it was interesting that they actually quantify how much training they think that a Title IX coordinator or investigator or decision maker at both the K-12 and higher ed level, how much training they would need annually to be brought up to speed. And they say 16 hours, which in my mind is much more than most schools are doing. During my time at OCR, I never saw anyone who was being trained at that level. But you should at least be aware that that's something that may be pointed to in an investigation down the road to say that your Title IX coordinator isn't adequately trained if they didn't receive that amount. So what's next? You can comment until January 28th. You can contact us with any questions or proposed comments, and then you also can go online and submit those comments directly to the federal government. That is their preferred method, is through this regulations.gov website.
Thank you. And so our next of three hot topics is the Pritzker administration's education agenda. And basically what we wanted to do here is preview a session we'll have at our school law conference that's coming up this winter, where we'll surely know more. But at this point, we have been monitoring that J.B. Pritzker has selected a working group to move his education agenda forward. It's co-chaired by the individuals on the slide. And what we expect is that they will be making recommendations as far as appointments at the state board. And we are lucky to have Nicki here, who actually was appointed to one of those positions that has an impact at the state board. She was former general counsel there. Nicki, what kind of things would you expect to come out of this process?
Sure. Thanks, Jen. So the first thing that I think the governor's team is likely going to look at is the selections or his appointments to the state board itself. For those of you who sort of keep up with these things, you'll recall that when the new governor comes in January, there will be 5 state board member terms that will be up at that point in January 2019, including the chair. And so the first thing they're likely looking at is who are going to fill those positions. There was also a new law or an amendment to the state board selection process that was passed this past year, which requires 3 board members who are appointed to come from the educator community. Although that term is undefined, we expect that means folks who have either served or are serving as superintendents, principals, district staff. So, there have often been, over the course of the state board's history, members from the educator community that have served on the board. Now it's codified in statute as required. So I think that will be their first focus.
Right. And we pulled, if you look at just some of the public statements that's come from the governor-elect, a couple key highlights are around funding. I've been at several speeches where this has been a focus, and unlike in the past where the funding formula was the focus, it now appears that just getting more funds into education and fully funding that formula is the priority. Another couple more minor but interesting ideas that have been floated include lowering the compulsory school age to 5, which could have some impacts. Occasionally that comes up when we're talking about what to do with truant, for example, kindergartners or that kind of thing. and also around charter schools, a possible proposed moratorium on additional charter schools. But we will look for more information on that and have that at our school law conference and offer a session on this topic. So next we'll turn to Nicki, who is going to cover guns in schools.
Great, thanks, Jen. So we wanted to just touch on this topic. I know it's come up more recently because of school safety and school shooting issues, and more specifically because, as some of you may be aware, this topic was raised at the recent III conference. Representatives from the Illinois school boards considered a resolution at IASB's delegate assembly. The resolution called for the IASB to support legislation that would provide local school boards the option to decide if they will allow for properly trained staff to be armed in school buildings as part of the district's overall student safety and protection plan. Districts opposing the measure argued generally that arming staff would create not safer schools, but would actually lead to further problems. On the flip side, districts who supported the measure argued that the issue was about each district's ability to decide for itself what would work best for that district. The resolution was particularly supported by rural school districts who expressed concerns about emergency response times of law enforcement and others in their communities. Ultimately, it was debated. Ultimately, they voted against supporting such legislation. So at this point, IASB will not be coming out in favor, will not officially support legislation in any upcoming session. Obviously, the significance of that vote is symbolic, or it's what IASB is going to push for. It doesn't have any specific legal consequence for school districts. So there's still, our slide said it still lacks official guidance. The state of the law at this point is that while law enforcement can carry weapons in your school building, so your SROs who come from your local police department, no other school staff at this point can carry weapons in schools. We get asked from time to time about retired police officers serving as school security officers and whether they can carry concealed weapons or weapons in the school building. Our guidance at this point to that question is no, unless they are attached to a local police force as, say, an auxiliary police officer. There is a law that allows a federal law that allows retired police officers to carry weapons, but there's a specific exemption in that law that does not allow them. There's a carve-out on any prohibitions under state law restricting guns on public property. And as we know, in Illinois, there's no concealed carry in school buildings. And so even if you have a retired police officer who you'd like to have employed in your school district as an SRO, as a security officer, our recommendation at this point is to touch base with us, to touch base with your local law enforcement to determine if that police officer can be made, that retired police officer can be made an auxiliary officer of the local law enforcement agency. If not, our guidance at this point is that they will not be allowed to carry their concealed weapons in your school building.
This is also an area then where we would be just looking to follow to see if the state legislature is discussing this at all, if any bill comes through as well, to see how this might play out, if there actually is a potential bill or legislation on this issue.
Yeah, absolutely. We'll keep a note on this one. I know that this is a hot button issue for schools, and we'll certainly keep everyone posted if in the next General Assembly, starting this winter, if a law is proposed and how it passes through.
And we'll do the same for all of the issues that we've talked about today. So if you aren't already receiving our alerts, please go to our website or contact one of us to sign up for those. We've already been pushing out different information as it becomes available to us to make sure that you all are aware of what's happening, whether it's with the proposed Title IX regulations or new information that we might be able to get and then pass on to you on these issues. So we will continue to do that as well. So thank you again for joining us today. We hope that you found today's program helpful. If you have any comments or additional questions, feel free to reach out to us either via email as well as find us on Twitter. The next webinar in our series will be on January 15th, 2019. We will discuss then student mental health issues. You will receive an email today with a link to today's program recording and presentation, as well as a link to register for our upcoming webinar in January. Thank you again, and have a great rest of your day.